Good morning. Welcome to the first DCA. We have one case on our docket today, which is Avant Stay versus Beach Chasers. That's 250506. 15 minutes reserved per side. Counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes.
5 minutes. 5 minutes for rebuttal. So noted. You can proceed when ready, Mr. Norby.
Good morning. May it please the court. I'm Daniel Nordby on behalf of the appellant Avant Stay. This appeal involves the lease of a vacation rental property that was terminated following the discovery of mold throughout the property. I'd like to focus my time today on two legal errors committed by the trial court that require reversal. The first one is the trial court's application of the incorrect legal standard regarding the appellant's duty to disclose the full truth about its knowledge of the mold. The second is the trial court's erroneous construction of the lease provisions regarding appellant's right to terminate under the force majeure and casualty clauses of the lease. So first, as to the duty to disclose, Beach Chasers, the appellee here, had a duty to disclose the property's known latent defects.
That's only if it's a residential tenancy, right? If it's a commercial tenancy, then other than some exceptions to caveat lessee, there wouldn't be a duty to disclose.
I'd agree with that. So our argument proceeds in the alternative here. First, we believe that this is a residential lease for the reasons we've said in our brief. And as Your Honor mentioned, under Johnson versus Davis from the Florida Supreme Court, a seller of residential real property has a duty to disclose defects. That principle has been applied to the residential lease context as well. And we think this property is properly characterized as a residential lease.
On the big picture first, the Johnson v. Davis is for a sale of residential property. To my knowledge, and I'm sure you would have cited it if we had it or if the Supreme Court had said it, caveat lessee as opposed to caveat emptor has not been, there's not been an exception to that for residential property, as I understand it, from the Florida Supreme Court or from this court, right? So you're basically asking us to at least agree with some of the other DCAs who have said that on a residential tenancy there's an exception to caveat lessee.
So, Your Honor, we have cited the 3rd District's decision in Alvarez versus Diaguerre, and we've cited the Florida Supreme Court's decision in Mansour versus Eubanks. We certainly agree that this court has not specifically addressed the application of that duty to disclose in a residential lease context. Other courts have, and we think an extension of that principle makes sense here. And we have cited this court's case in Santa Monica Beach Property Owners Association on the definition of how to determine whether something is a residential use or whether it's a commercial use.
Now, Santa Monica, as I understand, correct me if I'm wrong, but that was a direct owner to short-term lessees, kind of vacation rental kind of thing like that. Here, though, we have Avant Stay as kind of a middleman, Beach Chasers to Avant Stay. Avant Stay is not using it as residential. They then lease the property out for shorter-term rentals to, Airbnb or whatever the case may be, right?
That's right. That's the business model that's happening here. And what this court said in the Santa Monica case is that you look to the actual use that's being employed of the property.
Is it the use by the lessee or the ultimate user that matters, or were we not specific on that in Santa Monica?
In that case in Santa Monica, our reading of it is that's the use by the ultimate lessee of the property. In that case, it was a case about residential use covenants rather than lease obligations.
Well,
but
I was on the panel of Santa Monica, and that's exactly what we said.
I was going to mention that you were on that panel. So the court said that the key inquiry is how the property is used, not the duration of the rental, not the fact that there might be money of it. A lot of lease contracts, in fact, most lease contracts ultimately result in someone being paid for the use of the property. But in Santa Monica, the court said that the guests use the property for ordinary living purposes, such as sleeping and eating, and that's what Avant Stay's guests would do as well in this context. So we think it's properly characterized as a residential duty to disclose. And on the facts here, Beach Chasers did not comply. It did not disclose facts known to it about the status of mold on this property. We've cited in our papers 3 different reports that Beach Chasers had before the lease was commenced here: the Cole report, the Superior Air report, and the Coastal States report. We've cited all of the citations in the record in our papers here, but those reports all mentioned mold-like substances, significant growth within supply flex runs going to the vents around the home. And the Coastal States report, I think, is the most significant, and it starts at page 1366 of the record. And the assessment there is suspect microbial growth in several areas. Most of the HVAC registers, the walls, the ceilings, the ceiling of the hallway. And that report recommended HVAC repair, installation of a whole house dehumidifier, remediation contractor, mold assessor, insulation, drywall, painting, $35,000 worth of repairs. The record here is undisputed that Beach Chasers had that report December 18th, 2021. That was about less than a month before it executed the lease with AvantStay. It did not disclose the existence of any of those reports to AvantStay. When AvantStay asked...
Wasn't there a disclosure at least of some HVAC issue that was in need of repair?
There was a mention of moisture issues that would be addressed by an HVAC repair. That was the only mention that was made. And that goes to our alternative argument. If you don't agree with our primary argument that this was a residential duty to disclose, even in the commercial context, the case law that we've cited is clear that if a person undertakes a duty to disclose, even if they didn't have that duty in the first place, they have to tell the whole truth. They can't give a partial disclosure, such as a disclosure that there's a moisture issue that will be solved with an HVAC repair, while holding back information about all of this mold that was known to them in the other reports.
But some of the other reports were well after the fact that the lease commenced, though, right? I mean, the HVAC problem and the leaking was before the lease commenced, but some of the more serious problems with the subflooring and those kind of things were only discovered after the lease had commenced and AvantStay's right to inspect had expired.
So Judge Bilbrey, the 3 reports I mentioned, the Cole report, the Superior Air report, and the Coastal States report, were all pre-execution of the lease. There were 2 other reports that AvantStay commissioned after the lease began, after it took possession of the property and started to discover mold under the tiles, rotting subflooring, and all of these other things that prompted it to do its own reports and further revealed that. And even throughout that whole process, Beach Chasers refused to provide these earlier reports, even when specifically asked. The Green Air Technologies report, which was the last one, was in April of 2022. That was one commissioned by AvantStay, and that's the one that led the contractor there to shut down the property, evacuate its personnel, and tape off the property. And for reasons that I think are understandable on this record, that led my client to decide that this is a condition that wasn't disclosed to it. Had it known about these conditions, it never would have entered this lease in the first place.
So the lease was signed January 10th-ish, and quite frankly, the property wasn't inhabitable or rentable until what, late June?
I think that's right. You're exactly right on the date of the lease. January 10th was when the lease was signed.
I don't know why I remember the date. June 22nd, I think, was when all of the remediation had been completed.
That's right. There was extensive remediation, and that's understandable given the sort of recommendations that were in these reports. Anytime you're thinking about taking all of the drywall and insulation out of a property, that's a substantial amount of remediation that's needed, to say nothing of the furnishings and fixtures and other things that AvantStay had moved into the property at the commencement of the lease, which it considered to be a total loss if there were toxic mold spores in the air. So that was an additional loss that AvantStay had in that context.
If we agree with you that either the casualty damage to premises, paragraph 19, or the force majeure, paragraph 20 apply, what do we do with the 30-day notice requirement and the fact that the letter terminating the lease didn't invoke either of those paragraphs? We just said we're terminating immediately. We're not abating. We're not taking any other options under the lease. We're done.
So, Judge Bilbrey, both the casualty clause and the force majeure clause provide AvantStay a right to terminate. The force majeure does require 30 days notice before the termination. The record here shows that Avantstay did pay for that 30 days. Nothing required it to stay in the property for the 30 days once it had done that. And nothing in the lease, contrary to what the trial court appeared to suggest, nothing in the lease specifically required Avantstay to use magic words citing to these specific subsections of the lease when exercising its right to terminate. Nothing in the lease required Avantstay to cite to the casualty clause or to the force majeure clause. The reason, I think, was fairly apparent from the language used by Avantstay in its letter to Beach Chasers. It had mold throughout the property. It had determined that it couldn't move forward anymore. Had it known, it would not have moved forward. So I think either of those could provide an independent reason for reversing the trial court's summary judgment order here. I see that I'm into my rebuttal time.
We'll be happy to give you some more time, but can I ask you just on the overarching theory that a Johnson v. Davis claim should apply to create an exception to caveat lessee? And nobody cited this, but my recollection when a common law is being modified, not just found, but modified. We got kind of criticized decades ago in Hoffman v. Jones when we went from contributory negligence to comparative fault. The Supreme Court, as I recall, I didn't look at Hoffman for this, but said only they can do those kind of things. So even if we agree with you, wouldn't we need to affirm but certify something to the Supreme Court to say, is there an exception to caveat lessee for a residential tenancy?
And I haven't read Hoffman
Right.
in a little while as well. I don't believe that it stood for the principle that only the Florida Supreme Court can apply the common law in a way that extends its principles. We think that this is a modest extension of that Johnson versus Davis principle to the context of a residential lease, to the extent that that hasn't already been applied by other cases. We cited Mansour versus Eubanks, which admittedly predated Johnson by a couple of years, but that case said that a landlord has a duty to reasonably inspect the premises before allowing the tenant to take possession and make repairs reasonably necessary. And then the Alvarez versus Daguerre case as well says that a landlord is under no duty to advise a tenant of a condition which is apparent, but if the landlord is aware of a dangerous condition which arises from a latent defect, it is his duty to disclose such a fact, and failure to do so may constitute negligence and render him liable for the resulting injuries. So we think that principle, that failure to disclose principle, is well established in the law of this state, even if it has not been specifically applied by this court in this specific context to a vacation rental context.
Thank you, counsel.
Thank you very much.
We'll add.
I'll reserve the remainder of my time.
And we'll add 3 more minutes to your time and 3 more minutes to the appellee's time also. Thank you.
Good morning. May it please the court. Aaron White, I'm here on behalf of the appellee Beach Chasers. This is a case about 2 businesses that entered into a commercial lease. We can look at the lease itself. It is a lease that the appellant doesn't like to focus on much, but the lease itself has many provisions that were negotiated and important, and I think demonstrate the type of lease you would see with a sophisticated set of parties who are commercial in nature. We have a pre-lease inspection process that allows Avantstay to go in, conduct inspections, find out what the issues are, and even terminate at that time. We have early termination rights if we, as the landlord, were not willing to make the repairs they want us to make. We have a notice and opportunity to cure provision if there's anything that's not right about the property, so that we can cure that. And very importantly, we have that the repair costs stay with the landlord. That's very important because all of the disclosures and misrepresentation allegations are really in the context of selling a property, where you've passed it on to a purchaser who is now stuck with maybe something wrong. Our client was always responsible. So if something happened on day 1 or day 365, all the way into that lease, they always had to repair it. There was no incentive, like there might be on the part of a seller, to pass off a bad property. They retained ownership of it, wanted to maintain it because they owned it, and they were legally obligated to maintain it. So the concept of, hey, we're just going to pass something off, it just simply doesn't apply here.
They never declined to do anything that needed to be done, correct?
That's absolutely correct, and the record also reflects that we actually went above and beyond. As an example, there was some mold on drywall that was discovered. Avant Stay wanted to paint over it with Kills. My client specifically said, no, cut it out. That's just one example. In fact, there was testimony by Avant Stay employees during the trial that our client always did above and beyond. The same with the repair that he did to the AC. He picked the most expensive option that they had. That's what the record shows. He was ready and willing. You can see in the record as well when this termination came across, immediate correspondence. Hey, if there's a problem, we have a lease. Let's abate rent. You don't have to pay. No harm to you. We'll get it fixed and let's move on. This can be a good thing for both of us. This is a great business opportunity. We made those overtures more than once to the executives, completely ignored, and the unilateral termination went forward from there.
Let's talk about the label of commercial versus residential. And is it your position that the fact that it was rented and income was received by Avant Stay, that this renders the lease or this scenario commercial?
Yeah, so what we've cited is the Agrabin case, cases like it. The Agrabin case is a residential condominium being sold. The purchaser is an LLC, and they're going to be using it to rent. But it's a residential piece of property. The court found in that case that that was a commercial transaction. We are citing to this court that the transaction should be reviewed. The Santa Monica case, line of cases that Your Honor said you were a part of, is obviously a restrictive covenant case. And in fact, I highlighted in that case, it specifically says in the context of restrictive covenants, before going on to state the conclusion, those types of cases, and I do a lot of HOA work, are geared towards, are we going to have a business use in the middle of our nice little residential community? So they want to know, is the outward-facing look of this use going to be different than the neighbors? Is there going to be a lot of traffic, extra noise,
Well,
things
and
that are
here,
commercial?
if we put this in context, the renters were using it for sleeping, eating, lodging. So quite frankly, when I pare it down, really your argument comes down to, because Avant Stay is receiving rent or income, that renders it a commercial property. We're, disregarding the actual use of the property to the renters.
Yeah, so a couple of things on that. Our focus is on the transaction and the disclosures required for that transaction. So the Agrabin case I cited, there's no doubt that that wasn't a residential condominium. But they looked at, it's two businesses.
Well, and if we look at transactions, and I expected that to be your response. So I went back and looked at the lease just from the context of, I'm gonna look and see what elements of this lease, which both of you entered into, are pro or con with respect to a residential use of this property. You've got, and I made a list of home inspection. There's several references to HOA, and I found it interesting that the lease that you signed actually requires your company to buy homeowners insurance. And
Yes, ma'am, there's no doubt.
most homeowner insurance policies exclude renters. So quite frankly, that sort of language in that lease, does that not favor appellants in terms of, if we're looking at actual use, this is residential?
Yes, and so a couple of distinctions there. There is no dispute, just for clarity, that this is a residence. It's a duplex. It's a residence in Panama City Beach. The Santa Monica case that we've been talking about specifically says, in the context of restrictive covenants, the determining whether short-term vacation rentals are residential uses of the property, the critical issue is whether the renters are using the property for ordinary living purposes. So our position is that case is a niche in, as it says, in the context of restrictive covenants. So the use argument, at least this test doesn't apply in our opinion. In the Agrabin case, the actual transaction does. Now, we cite this in our brief. You have an example, the Wasser case. It involves an apartment building. We know that the end user is ultimately going to be a person using it for residential purposes because it's a residential property. However, what was important in the context of that being commercial is we have businesses entering into a transaction to buy a property.
And I'd like to hear from you as well on what's the justification, and I'm referring to Haskell opinion. I think that's an interesting opinion laying out the different issues with caveat lessee, if it applies to commercial property. What's the justification for an exclusion for commercial property?
Yes, ma'am. So this DCA in 1993 gave us the Haskell opinion. In that opinion, there was some, ultimately a certified question to the Supreme Court on should that issue be taken up and should that still, a caveat lessee or emptor still apply. And the court really focuses on the fact that there's kind of in the margin potentially a small business who isn't really, maybe has more the feel of a non-commercial renter or purchaser because maybe they just opened up an LLC and they're really still a small guy. Well, that very much doesn't apply here. We're not in the margins. We have an international rental company on one side. We have a very sophisticated contract that I think exemplifies exactly why these purchasers and lessors that are commercial don't need protection.
If we were to disagree with you and say that Santa Monica compels us to say this is residential, and we say that Johnson v. Davis claims apply, nonetheless, the trial court covered that, right, and said that even if all of those things happen, there's still not a failure to disclose known material defects, which is if I sell my house and it's got black mold in it, but I didn't know about it, and you're the purchaser of it, then I'm not liable unless I knew or should have known of it, right? So isn't that the same thing here?
Yes, sir. And I have, that marked in my notes is very important because even if this argument is accepted, the court already, for our benefit, went down some of those alternative paths and told us even if there was a duty, it wasn't violated in this case, and was very clear that there were no findings of any type of misrepresentation, non-disclosure, fraud. There was no evidence of that.
Is that a factual issue or a legal issue?
Well, I think it's probably mixed. The court heard 4 days of testimony and determined that there was no fraud. Also, very importantly, in the context of both Alvarez and Johnson versus Davis, it has to be latent in order for there to be a disclosure obligation. In this case, the record's clear that there was visible surface suspected mold. So the condition of mold was never latent. There was some mold discovered later behind a refrigerator, which you could say, but the idea that there was mold in the property was well known to everybody. So even if we said that those two standards apply, there could not possibly be a violation based on the mold. So you get there either way, either finding residential, then you look at the latency issue. If you find it's commercial, same result, the trial court's ruling is affirmed.
What do we do with the force majeure clause? Paragraph 20 has some pretty broad language on the other causes there that makes it more expansive than some of the force majeure clauses that I've seen before. What are we to make of that?
Yes, sir. The force majeure was something that the court analyzed and ultimately, after hearing all the testimony, determined it was a theory that was first derived really in litigation. In looking at the two notices, there were two termination notices in this case. Neither of them invoked it. Neither of them, and not necessarily invoked it by saying, paragraph 20 of the lease, but even mentioning any of the language. That was never done for force majeure. But the court looked at it and ultimately analyzed, I think correctly, this idea of materially inhibiting the tenant's ability to operate. That's key because the court tells us, well, almost anything, a small oven fire, maybe your AC goes out in the summer. There are a number of different things that inhibit. But when you're talking about a multi-year lease, we have to determine what's material. We know from the record that AvantStay never attempted to determine the materiality of this condition. In other words, when we asked them at trial and deposition, when you got these findings in April, did you go and say, hey, is this a 1 week problem? Is this a year problem? How long is this going to take? Is it going to be, the cost didn't matter because that was going to be on my client. But the timing, you would say, that would tell you if it's material. Well, they never bothered to do that. They never asked. We told them we were willing to do it. Ultimately, we know that it was something that could be remedied pretty quickly. We had a 12-day mold remediation done. While we were in there, we also repaired the floors that everyone knew about, had some dampness issues. So ultimately, all told, while managing this from California, they get it done in about 45 days at a very reasonable cost. They're asked in deposition and trial, had you known this was a 45-day problem that our client was willing to pay for, would you have done it differently? And both their CEO and their CFO said yes. But they didn't bother. The simple question, you have a mold assessor come out. They tell you have a problem. Isn't your first question, is this going to be a big problem? What do I need to do? How long is this going to take? The fact that they didn't ask that question shows they had no real intention of invoking force majeure. They just wanted to get out. And
Well, what information did they have specifically prior to AS performing the assessment, which they gave the report April 26 when they terminated the lease? Prior to that time, prior to that inspection and the severity of the situation, what information did they have that advised everybody of the severity of the situation?
They had a tremendous amount of information, and the court found that we were all on equal footing up to that point. It was a surprise to everyone when they found it behind the refrigerator. So the information that they had starting from the beginning on January 15th, they received their home inspection report, which they opted to do after they entered the lease. It showed various surface suspected mold around air registers on the walls. There's this kind of corrugated metal decorative piece that came up against the drywall, and there was evidence around that had been kind of creating condensation on the cold and hot surface. So they knew all about that. And there was the flooring. So then they get in there, they start onboarding this, bringing it into their system.
Well, specifically, I'm referring to back in mid-January. It looks like AS got ServPro to do an inspection.
Yes.
And AS provided your client with that inspection.
Yes, ma'am.
And they asked you at that time, look, we may have some more issues. They asked you at that time for the Coastal States report. You didn't give it to them at that point or disclose any of the information you had before. At what point did you provide that Coastal States inspection report?
The Coastal States letter wasn't provided at that time. When they found, they had their own report. Then they went out. They were the only ones there. They were physically there. Our clients were in San Francisco. So they were there. They were starting to get the place ready, get it fixed up. There was an agreement to repaint it. And they started encountering some mold. They pulled off the metal piece. They found some behind, and that's the picture with, hey, let's kills it. And we say, no, let's cut it out. So they actually start gaining a lot of information. They see that the floors are wet, and they start talking about there's mold under those floors as well. They actually, they decided not to have ServPro come out at that time. They had their maintenance person handle it. But what we didn't know is that they actually did have ServPro come out later, pull back some metal and some of the bunks, found mold, never even told us about it. It came out at trial that they had done that, and the explanation was, I guess we just forgot to tell you. So they actually had more information than we did about the extent, because our inspections just like a home inspection, was just done walking around. There was nothing torn off, cut into. They actually gained the benefit of cutting into things and opening it up. So the fact that they waited until April, they knew about mold, suspected mold, by January 15th. And it was, you can see in the record, countless emails. You can see Mr. Coffin, who was the head for them. This mold isn't doing us any favors. We're having to deal with this. We're having to deal with that. They find the wet floors, and again, they say, let's put that off to the off season. So the way they handled mold, suspected mold throughout the process, was very nonchalant. Let's put kills over it. Let's do the repair in the off season. Let's just get this thing rented. Then all of a sudden, the flip switch in April, and they wanted to terminate. They didn't want to talk about it anymore. They didn't want to remediate. They just wanted out. And they, at that point,
the units had been biohazard taped off. Nobody could even go in.
Well, that's a little bit of a dramatization, and that's not, I don't think, supported by the record. But there was a mold finding, which, as the court's aware, is not an uncommon thing in Florida to have mold. We have companies that are certified by the state of Florida to remediate it, and that process happened. It was also, the record did not reflect that it was taken down to the studs. That's not what ultimately happened, that the house had to be completely gutted. That didn't happen. You can tell that by the time frames and the costs.
But it was late June before it was inhabitable?
So it was in June, so it was about a 45-day period. About 12 of that was the mold. They also went ahead and took care of the floors that everyone knew about. And just some efficiencies of it wasn't all done back to back. They were managing it from California. So the record reflected it was about 45 days. And this is a multi-year lease. And again, no harm would have been done to them because we were willing to abate during that process and pay for it in full, and the record reflects that.
Your time's expired. Counsel, if you want to wrap up.
Yes, thank you. We're asking the court to affirm the trial court's ruling, obviously. We're asking the court to find that it properly assessed this as a commercial lease, and even if it did not, that the residential standards being applied, we would still find that there was no non-disclosure of these conditions which were not latent. We're asking the court to affirm the competent substantial evidence that the lower court took over 4 days in determining and hearing from the testimony of the witnesses that there was no misrepresentation, fraud, anything of that nature in this case, and that the parties had the same information and the same access to information. We're asking the court to affirm. Thank you.
Thank you, counsel. And let's add another minute to Mr. Nordby's rebuttal time. Thank you.
Thank you very much. Just a few brief points in rebuttal. My friend on the other side characterized my client's reaction as nonchalant. I don't know that that's a fair reading of the record. I think it would be equally fair to describe the record as Avance trying to make this deal work out when told that there were some moisture issues that would be solved with an HVAC repair. And only later, after the property is taped off and there's talk of toxic spores, realizing that this isn't a deal that's going to work for them anymore and exercising its rights under the contract. On the right to inspect, certainly we acknowledge that Avance had a contractual right to inspect the property, but the right to inspect does not foreclose the duty to disclose on the part of the property owner. I'd point the court again to Johnson versus Davis, which itself had a buyer that had a right to inspect and get a report on the roof condition. They didn't exercise that right, and in that case, the Florida Supreme Court held that the seller had its own duty to disclose something known to it, notwithstanding the buyer's right to inspect the property.
What do we do if it's a residential tenancy? We agree with you on that, and we agree with you that Johnson v. Davis claims apply to a lease. What do we do with 8356 per N1 on termination of a rental agreement that has the 7-day written notice specifying the non-compliance? You certainly can withhold rent while it's not being in a habitable condition, but you've got to have at least a 7-day notice to cure. Does that apply here, and if so, how does that apply?
So I think that applies to our implied warranty of habitability claim, which is one of the many claims that we have. The trial court ruled on, I think, 14 affirmative defenses and 6 counterclaims here. Implied warranty of habitability, which is where that provision goes to, is one of the claims, and I agree that would apply to that claim. I don't believe that that requirement would apply to the other claims that we've raised, the misrepresentation claims, the failure to disclose claims, and so forth. But to the premise of your question, which is the residential versus commercial treatment here, it frankly would be surprising if the owner of a residential apartment complex could avoid all of the duties that the law imposes on residential lessors by simply hiring a property management company as an intermediary that then handles the direct leasing to the residents of that property, and that turns it into a commercial lease.
What if I'm a big venture capital firm and I own a whole bunch of apartment complexes? I sublease those to somebody on the ground who's a company that's in the business of doing the marketing and the renting and that kind of stuff. And then that my lessee, I guess, then subleases it to individual tenancies. Wouldn't that be a commercial transaction if I'm owner of the property, leasing it to somebody who's going to lease it to somebody else?
Yeah, I mean, I think in any kind of multi-level transaction like that, there may be privity aspects that would limit the rights that one contractor may have against another in that sequence, absent third-party beneficiary type of issues here. But in this case, we have directly a contract between Beach Chasers and AvantStay. This is not, for example, a claim being brought by a guest of AvantStay who is staying at the property. We never got to that point, but that may impact the analysis if we were to get there. But the ultimate use of the property here does not cease to be residential simply because of the way that the entities are structured in this.
But this is very different from you owning a beach house and you get Sand Dune Realty to manage it, which means they handle the reservations and they clean it. This is very different from that. Wouldn't you agree, this contract?
Oh, I'd agree. This is not simply a cleaning and management contract. I'd agree with that. Yes. Judge Bilber, you'd asked a question about what we do with some of the alternative conclusions in the trial court's final judgment here. Some of the issues that we have challenged in our brief here were not resolved following the trial. They were resolved at an earlier stage on summary judgment because these duty to disclose factors go into multiple of our affirmative defenses and claims. So to the extent that the trial court resolved something on summary judgment under the wrong legal standard, if this court were to conclude that, then the result would be to reverse and remand either for application of the correct legal standard, or if this court finds the facts undisputed, this court could, of course, apply the correct legal standard to the undisputed facts. So those alternative conclusions that if there was a duty, it was met, and based on the factual findings at trial, don't apply to those issues that were resolved at an earlier point in the case on summary judgment. Judge Thomas, to one of your points earlier on the residential nature of this lease, in addition to the many provisions of the lease that you cited, I'd also refer you to record page 1699, paragraph 5, which required that this property be legally permitted for residential use as a single-family residence. This is not a commercial or business transaction here. Finally, the force majeure provision, I'd agree, Judge Bilber, with your observation that this force majeure language has broader language than you sometimes see in this context. There's a catch-all in that provision that says any other cause other than a solely financial cause. There's certainly nothing in this record that would indicate that AvantStay sought to terminate this lease under the force majeure provision for financial reasons. I think the record is pretty clear that it was the mold that was discovered and ultimately came out over the course of all of these reports that led AvantStay to decide that it had to terminate this lease.
And fixable, and fixed.
Excuse me?
The problem was fixable and it got fixed.
The problem ultimately was
And would
fixed.
not have been their financial burden.
We learned, of course, only after the termination how long it would take to remediate this property. We did not know that at the time. What we knew at the time we exercised this was that reports had not been provided despite request. My client conducted its own report, and they put up biohazard tape and got out. So I think they made a reasonable decision to exercise their contractual rights here, and they did so. We just asked this court to reverse on any of the grounds that we've argued.
Thank you,
Thank you.
counsel. Thank you both for the argument. We appreciate it. And with that, we are adjourned.